I'm Ben Meiselas from the MeidasTouch Network, and this is a legal breakdown of the Department of Justice's opposition with the United States Supreme Court of Donald Trump's application that he had filed on October 4th, asking the Supreme Court to vacate or to essentially overrule the 11th Circuit's order partially. The part of the 11th Circuit's order where the 11th Circuit said that the special master would no longer have access to the 100 classified records and that Donald Trump would not get to see those classified records. Recall the 11th Circuit granted the Department of Justice's motion for partial stay on September 21st, returning those records, saying that the Department of Justice can utilize the 100 classified records. Remember, it was limited to those 100 classified records, that they could use it in connection with their criminal investigation. That's not the part that Trump is seeking the application to vacate. Just the portion where the 11th Circuit says Trump can't look at these classified records through the special master process. And Trump's like, me, mine. I want to look at him. And the Department of Justice was like, the Supreme Court, he has no basis to look at him. And Donald Trump argued, the 11th Circuit, 2 Trump judges, 1 Obama judge. That was the panel. He said they were demonstrably wrong. That's the standard he has to use. They should never have asserted appellate jurisdiction. No. You know who should never have asserted jurisdiction? Judge Eileen Cannon. She should never have asserted equitable jurisdiction, and that's what the Department of Justice pointed out. The weird posture of this whole case is because you had some judge who Trump appointed assert equitable jurisdiction in a case that she had no jurisdiction. And so the 11th Circuit had to jump in, and her order, Judge Eileen Cannon's order, was an injunction. And Trump's arguing, oh, it's not an injunction. The special master part's not an injunction. The 11th Circuit can only rule on issues of injunctive relief. That's where they could overturn it or grant a motion for partial stay in an interlocutory basis, meaning before a final judgment. And the 11th Circuit held in their decision, and the Department of Justice argued to the Supreme Court, look, the 11th Circuit has what's called pendant jurisdiction to rule on issues that are inextricably intertwined, and the issue of the special master and the Department of Justice's access to these classified records are intertwined. Boom, 11th Circuit has jurisdiction there. Number 2, it is an injunction. The overall order at issue is an injunction. Just because Judge Eileen Cannon's a sloppy judge and who knows what the hell order she wrote, it's still an injunction. What the appointment of the special master and the documents that were temporarily prevented from the Department of Justice accessing, that's all part of one injunction order, of course. The 11th Circuit can make a ruling and assert appellate jurisdiction and has jurisdiction there. And also, the Department of Justice argued it is a collateral order, meaning it is a final determination reached by Judge Eileen Cannon where the bell cannot be unrung. Once Donald Trump gets access to these classified records through a special master process, that's final. That's a collateral order. The Department of Justice will have their entire criminal investigation compromised. That is another bases for the Department of Justice to argue validly and for the 11th Circuit to accept the argument that the 11th Circuit Court of Appeals, of course, has jurisdiction. We did a bigger update, a longer update on the filing before the Supreme Court where the Department of Justice made those arguments and went through the standard. So watch the longer video, but I want to focus on a gem that I found in this Department of Justice opposition filed to the Supreme Court. And it's a part that really hasn't been emphasized enough in prior briefings. But, notice the Solicitor General here is actually the author of this opposition, Elizabeth Prelogar. And Solicitor General Prelogar is incredible. She's brilliant. She's bright. She's a 2008 graduate from Harvard Law School. Just watch her oral arguments, Prelogar's arguments, some of the most incredible oral arguments. But she was involved in the drafting of this document. I want to show you the gem in a second. First, I just want to go through, the most basic argument that she made, why Trump loses here. Number 1, here are the standards that Trump had to prove if he wants the Supreme Court to issue this Trump's emergency order right now, which would vacate or basically overrule the 11th Circuit's decision that the special master should not have access to the classified records. There are standards. One, the case very likely would be reviewed by the entire Supreme Court upon final disposition in the Court of Appeals. In other words, is this the type of rare case, those 2% of all cases out there, where the Supreme Court actually grants certiorari on a novel or new issue of law, or where there is a conflict between circuits that the Supreme Court needs to resolve? And here, setting aside that the answer is obviously no, there's no novel issues, Trump never even made the argument here. I mean, one of the things that the Solicitor General puts in this opposition is Trump didn't even attempt to argue this factor. Like, he's not arguing what the factors at issue are here. And then the other main factor, the number 2, was the Court of Appeals is demonstrably wrong in its application of accepted standards in deciding to issue the stay. There, Trump only argued the 11th Circuit had no jurisdiction. It was the arguments that I just went over with you. But number 3, Trump's rights may be seriously and irreparably injured by the stay. Trump has to prove that. The Department of Justice, the Solicitor General's office, arguing to the Supreme Court, said, again, Donald Trump didn't even make this argument. He didn't even argue. Factor 3, applicants' rights may be seriously and irreparably injured by this day. And also, look what the 11th Circuit said. How could he be injured? You can't steal records that don't belong to you and say, oh, I'll be injured if the records aren't returned to me. They're not yours. The Department of Justice says, the Solicitor General says, he's never claimed a possessory ownership in the classified records, never claimed that he has these records, and nor could he because they're not his. They belong to the executive branch. He stole them, the Department of Justice argues, and nor did he even argue it. All right. That's why Donald Trump should lose. You'll hear my analysis in the other video. The emergency decision here by the Supreme Court goes to one Supreme Court justice. In this case, it's Clarence Thomas, who happens to oversee the 11th Circuit. That's his assignment. The Supreme Court justices are assigned to issue emergency orders. On different circuit courts, he's assigned there. I still don't think, even though we know Clarence Thomas, the law is so against Trump here that I can't imagine Clarence Thomas actually will find that the 11th Circuit had no appellate jurisdiction, especially the 11th Circuit's known as a more right-wing judge, and so that makes rulings that Clarence Thomas usually agrees with. And here we had 2 Trump judges and 1 Obama judge on the per curiam decision, meaning it was a unanimous decision by the 11th Circuit. So I would be shocked and surprised, even with Clarence Thomas. But I guess you can't be too shocked when we're dealing with Clarence Thomas there. But even if Clarence Thomas makes the emergency decision, it's revisable by the entire court, and Clarence Thomas can have the entire court make the decision, and so we'll see what happens there. But that's not the gem that I want to show you. And this is the gem, an argument that really wasn't made in prior briefing, that I always thought should have been made a little bit more aggressively, and it's that to the extent Donald Trump is claiming this is a Presidential Records Act dispute, one, it isn't, because he didn't follow the Presidential Record Act procedures. He didn't give the records to NARA where they belong. And then if you want to challenge after NARA has the records and you want to make these claims, oh, this was personal property, this property didn't belong to the government, or these documents should be mine, or the Kim Jong-un letter belongs to me and not them. The process is you turn them over to NARA, and then you can fight it out, and the D.C. courts have jurisdiction over it. And there's a set process for who would have jurisdiction if you're fighting that out. Here, Donald Trump stole the records. It didn't go through the Presidential Records Act process because Trump stole the records. But if Trump is claiming this is a PRA issue, okay, then it shouldn't go in front of Judge Eileen Cannon. PRA issues, Presidential Record Act issues, should go to D.C. And this was a great point that's raised in this brief. And it goes, applicant's reliance on the PRA is misguided because he did not comply with his PRA obligations to deposit the records at issue with NARA in the first place, the National Archives. As a result, the archivist does not have custody of those records, and the PRA's procedures do not apply to them. Even were that not so, any dispute over access to presidential records under the PRA must be resolved in the District of Columbia, not the Southern District of Florida. 44 U.S.C. 2204E. If Trump truly believes that this suit is governed by the PRA, he has filed it in the wrong court, which would be yet another reason that the government is likely to succeed on the merits here. They take one more jab at Trump here, which I love. They go, as for applicants' former authority to declassify documents, despite asserting that classification status is at the core of the dispute in this case, applicant has never represented in any of his multiple legal filings in multiple courts that he in fact declassified any documents, much less supported such a representation with competent evidence. Indeed, the Court of Appeals observed that before the special master, Trump resisted providing any evidence that he had declassified any of these documents, and that, quote, the record contains no evidence that any of these records were declassified, and in any event, any such declassification would be irrelevant to the special master's review for claims of privilege and for the return of property. As the government has explained, the classification markings establish on the face of the documents that they are not applicants' personal property, and the documents likewise cannot contain information subject to personal attorney-client privilege, since they are necessarily government records. Thus, as the Court of Appeals emphasized, applicants', quote, declassification argument is, quote, a red herring because declassifying an official document would not change its content or render it personal. He stole government documents. The classification markings for purposes of this just show us that they're not personal documents. And if he moronically and dangerously and traitorously declassified like nuclear secrets and records. One, you can't declassify nuclear secrets, but if you declassified serious national security documents that could harm and lead to people dying, and you did that so irresponsibly, it wouldn't change the fact that you committed a crime under the Espionage Act. It wouldn't change the fact that you've engaged in obstruction. It wouldn't change the fact that you've engaged in concealment of government property. Classification is not an element of those crimes. And in any event, you haven't put forth any evidence that you declassified it. You went on Hannity and said you telepathically declassified it. Well, make that argument in court. Do the telepathic declassification argument in court, Donald Trump. You know, when I read briefs like this from Solicitor General Prelogar, when I look at the 11th Circuit ruling, we should all be thankful that in our court system, in our judiciary, it was the last institution to hold up our democracy. Now, we can't take it for granted. The stress test almost broke in 2020. Fortunately, the federal courts rejected all of Donald Trump's frivolous lawsuits, baseless lawsuits. They didn't submit any competent evidence to support any of their outrageous claims. In fact, the evidence was so fraudulent and bad that many of Trump's lawyers in those cases are disbarred, facing discipline, having massive amounts of sanctions. Massive amounts of sanctions. The courts held. The courts have still held right now. The 11th Circuit, 2 Trump appointees, 1 Obama appointee. Because you have to, when you deal with this, you have to deal with logic when you read these opinions. And Donald Trump stuff is illogical. But you see the threat. Judge Eileen Cannon is the threat. Judge Eileen Cannon asserting jurisdiction over a case she should not have asserted jurisdiction over, creating all of these issues now in our judicial system. Just think about all the resources right now that are being spent because Judge Eileen Cannon thought of herself as Trump's water carrier, as Trump's stooge, not upholding law and order. Law and order must mean something. It's not a slogan. It's not a mantra if there isn't anything behind it. That's why I do these videos. That's why we have these conversations. That's why we lean into the work we do at MeidasTouch. Because it is important that now that you learn these facts, that you go out there and you take these facts into the world and you teach people and you share these videos. You share these videos. We educate people because we can't allow that disinfo to spread. I think if you give people this information, we go through it, we go through, we show you where the things are, we show you the opinions, we read it together, we do this detailed analysis. We need to undo. I think that's the antidote to all of this MAGA disinformation out there. That's why we do what we do. Anyway, hit the subscribe button. We are on our way to 1 million subscribers. Thanks to you. Hit subscribe right now. In addition, if you want to help grow this independent media channel, one way you can help is by going to patreon.com/MeidasTouch right now. That's patreon.com/MeidasTouch. There are a number of exclusive benefits there, from behind the scenes footage and photos to postcards for me and my brothers, to you could become an honorary producer and your name will appear on the MeidasTouch podcast, on the YouTube podcast. Most importantly, help grow this platform. We take no outside investor money and we're fueled by democracy and powered by you. So head to patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.